Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser. Welcome to Conversation with Lee Presser. My guest today is Tad Armstrong. He's the founder of the ELL Constitution Clubs. ELL means earn it, learn it, or lose it. The ELL concept was established to bring an understanding of the United States Constitution to as many Americans as possible. Small groups of citizens meet monthly to study the Constitution and how the Supreme Court has interpreted it. Mr. Armstrong also writes a monthly opinion piece which appears in the St. Louis Post-Dispatch. His commentaries speak to constitutional limits on government authority to take certain actions. Today we're going to talk about the supreme law of the land, the United States Constitution. Tad Armstrong, welcome to the conversation.
Good to be here, Lee.
Well, I hate to sound, big about this, but when we talk about the Constitution, that's a mouthful.
It is.
I mean, you spent, 4 years in a course just trying to get people to understand the basics of it?
I have. To put together about a 3,000-page treatise, it took that kind of time to do it. And we have clubs all over that are learning our basic principles again. Remind people,
what is it that happened? There was an incident that happened that caused you to say, I got to move down this road. Something at a donut
palace in Edwardsville. I tend to go in there before I start my work day. Coffee clutch, like
You're an
many
attorney,
people
by the
do.
way, in Edwardsville,
yes.
Illinois. Okay.
And I mentioned one day to a local developer in town that I was so frustrated about the knowledge of the law, and in particular the Constitution, from what I overheard people say at the coffee clutch in the donut palace. All the time, and he challenged me to do something about that, so we did. We started a very informal gathering that met once a month, and it is now, we're now in our 7th year. We've had clubs all over the Metro East, and I'm trying to take this national with my program. Mm-hmm. And in Edwardsville High School as well, and we've also started our 2nd high school since I talked to you. This fall at Marquette Catholic High School in Alton. Mm-hmm. And that program is very successful. Mm-hmm. So that's our goal, is to take this national so we learn again what our principles are all about. Several people have said this, Reagan in particular, but you don't inherit a knowledge of what freedom is about and the principles of our Constitution. You have to learn it. And that's what we're trying to do.
In addition, we're going to talk about this in a little while, but you also have a book that's coming out?
I do. Hard to know exactly the going live date for it, but we're emailing in our final galley proof today.
Okay. Well, we'll get to that. Let's come back to Let's come back to the beginning here. So, you have a conversation with a fellow. Mm-hmm. Next thing you know, you're talking to small groups.
Yes.
And you have, over time, developed a series of scripts. Is that basically
a series of over 3,000 pages of material mm-hmm. that the members of the clubs get to read in the ensuing month.
So this is more or less self-taught then, with the discussions to crystallize the ideas.
It requires some pretty intense reading of Supreme Court opinions, because our fundamental philosophy is you cannot get the truth about these important concepts unless you read the Supreme Court opinions, which for the most part an average layman can do without mm-hmm. any problem.
Mm-hmm. Well, I have read any number of Supreme Court decisions, and I'm always amazed when I hear news reports about that very same decision, and it's like, where in the world did they ever get that conclusion that they're telling millions of people is what the Supreme Court said, when you read the face of it and it's different?
Well, that's why we use the Supreme Court opinions as our basic tool of education, because there's a lot of books been written about the Constitution, newspaper articles about decisions that come out, but what those say and what the truth is are oftentimes quite at odds with each other.
Would you like to give an example or two?
Oh goodness, off the top of my head, I don't know. There's a lot of examples. Nothing comes to mind right away.
Well, I don't want to go too deep into it, but we did have a discussion before we went on the air about a very controversial decision called Citizens United. And would you say that that's one of them, where the press seems to be saying one thing, where the court has actually written another?
Not only the press, but the President of the United States. He mentioned that case.
The law professor, president.
Yes, the constitutional law professor, president. He mentioned that case at his State of the Union last time, I suppose. And that's when Justice Alito he was seen to mouth, "That's not true." And Justice Alito was correct. The comments made by the president were not factually correct. It's a very complicated decision that many people quote in error. One of the glaring facts about the case that they fail to mention is that prior to that decision, corporate-owned media outlets had a lot of exemptions that other corporations did not have to abide by. One of the things this case did was put them back on the level playing field with other corporations. Well, you wouldn't find a typical media outlet saying much about that, would you? They don't like the case. Part of the reason they don't like the case is that they are now on a level playing field with other corporate bodies. It's a lot more complicated, but that's one example.
Well, let's go all the way back to the main decision of Marbury versus Madison. 1803. Yeah, 3. I was going to say 4, but
1803.
3. Yeah. In summary, let me just say, as I understand the case, that in the closing days of the Adams administration, a fellow was given an appointment to be a Justice of the Peace, I believe.
Correct.
But unfortunately, the administration ended before there was a final signature by the Secretary of State of that era.
Actually, there was a signature.
There was a signature.
Just not a delivery of the document.
Okay, so it was official. He just didn't get his
piece of paper.
His piece of paper.
That's right.
And so when the new administration came in, the new Secretary of State, who was then Madison, James Madison, later president.
Different party.
Different party, wouldn't sign.
Wouldn't deliver.
Wouldn't deliver. Well, he wouldn't sign or deliver.
It was signed, but he would not deliver the commission to Mr. Marbury.
And so then the next thing you know, this case, Mr. Marbury, decides he's going to the Supreme Court of the United States about this.
Filed a lawsuit in the Supreme Court.
Right. And then he has, then there's, as I understand it, this is a big to-do. It's like then John Marshall, who was the Chief Justice, knew that he was going to be tangling with Thomas Jefferson, and they didn't like each other to begin with. And so he did not want give Jefferson an opportunity to embarrass the Supreme Court by making a ruling in which then the Jefferson administration just say, okay, fine, we hear your ruling, we're not doing anything about it.
That's part of the saga.
So then I understand that Marshall sort of decides, well, I'll tell you what, this whole thing was based upon legislation which was defective in the first place from the Adams administration days.
Yes.
And we're just going to say, well, that was never legal to begin with. So the signing of the document meant nothing.
The legislation actually it wasn't the signing, the legislation that you're talking about, that is correct, added to the original jurisdiction of the Supreme Court by an act of Congress. It added the act of mandamus to their original jurisdiction. Mandamus meaning simply you're asking the court to make a public official do what they're supposed to do, in this instance, deliver the commission. Well, John Marshall determined that, after all, I took an oath to support this Constitution. And the Constitution doesn't give me that jurisdiction in the Supreme Court. That has to be filed in a different court. And so his answer to the lawsuit was to dismiss it in that they did not have jurisdiction to hear it. It was the first time, first celebrated time anyway, that the Supreme Court had struck down an act of Congress. By the way, the interesting sidebar to that is, John Marshall was the Secretary of State under Adams that failed to deliver the commission. And he was also the Chief Supreme Court Justice rendering the opinion about what he had failed to do. He doesn't say anything about that in the opinion.
So very incestuous here.
Yes,
very
fascinating,
incestuous.
yes.
So from that case forward, now the Supreme Court has established itself as an arbiter of what is and what is not to be seen as constitutional law.
Slight technical addition to that comment. Actually, all branches are arbiters of constitutionality. They all take an oath to support the Constitution. The President does as well, a little bit differently worded, but fundamentally the same thing. I would say they've established themselves as the final arbiter of what is or is not constitutional, with one slight exception, and that would be that the ultimate final arbiter is the people. We can always amend the Constitution if we don't like a decision.
There is a section of the Constitution very rarely used and little known by most people that says in there that the Congress can actually limit the areas of inquiry of the Supreme Court or the court system.
You'd get some opposition to that, but I agree with you. In fact, some of the Republican candidates have argued recently that they would like to limit the jurisdiction of the Supreme Court in some areas, for example, same-sex marriage. And I believe they could do that. It's been done in antitrust law. It was done a little bit with one of the recent congressional acts having to do with Gitmo and appeals from Gitmo. I believe that can be done. It has to be done very carefully, but I'm not in favor of it, by the way.
My understanding is that Mr. Daschle, the former majority leader of the Senate Democrats, when there was some legislation that had something to do with his state of South Dakota, that he put a provision in there that courts couldn't intervene in that. I'd have to look that up. I mean, this is something I've heard. Yeah. I don't know it for a fact, but
I don't recall that. But there's a number of other ideas floating around lately with the Republican presidential candidates. One is to limit the term of Supreme Court justice. One would be to establish an age limit for a Supreme Court justice. Others are to do away with an entire circuit court of appeals, in particular the Ninth Circuit. Conservatives don't like them too much.
This sounds like an article I've read.
It is.
Dispatch.
It is, but to expound on it a little bit, all of those ideas, in my estimation, are just fraught with serious problems. For example, let's just take an age limit or a term limit. Can you imagine the politics that would be played if an important case was sitting on the desk of the Supreme Court and everyone knew that an age was about to be hit where a person was forced to retire, or a term limit was up? I don't think we want to go there. I really don't. And the idea of lifetime appointment, of course, the Constitution says they shall serve during good behavior. That is interpreted to mean for life. I don't know how else you could interpret it, which means they could be impeached for bad behavior, but the concept is you never know when someone is going to retire or die, and therefore you remove the politics of timing from some of these important decisions, and actually you ensure as best can be possible that the folks that take those seats are not influenced inappropriately in their decisions.
I could see where if the Supreme Court itself were to come up with some group of Supreme Court members that could say, hey, Justice so-and-so, he's just slipping, It's like, I remember on the TV show West Wing that they did a whole series about the Chief Justice kind of putting Supreme Court decisions in rhyme, and there was really some concern. Yes, that's television. That's not reality there. But I wouldn't like to see a lot outside. I think that it's best dealt with internally than externally.
Well, even then, you would have the same problem. You would have the politics going on with the conservative wing, liberal wing, depending upon who was getting a bit maybe too old
and
to
yet
serve.
Every time I hear a Supreme Court justice speak, and more now than when I was younger, I mean, on C-SPAN, you'll see them quite a bit speaking.
Right.
They always talk about the collegiality of the court, and that there is, in their opinion, no liberal or conservative wing. That, yes, they may vote more a certain way than others, but they deal with each other very respectfully. There's none of this arguing like you see on the floor of the House or the Senate.
Which some of the dissents that you read in the last few years, you have to wonder how they can do that, how they don't come to blows, for heaven's sakes, and some of the fierce language that has been used in the last few years. But no, they ultimately respect each other, and that's fine. But you know, as much as some of the justices maybe should have retired earlier than they did in the past, I have to leave it there and say that happens to be the best system, because anything else is fraught with serious problems.
I'm trying to remember. I cannot remember his name. Douglas. Justice Douglas?
Mm-hmm.
Yeah.
I met Justice Douglas, by the way.
This was a gentleman who stayed well beyond his physical capabilities. As I understand it, he was incapable of controlling himself physically anymore. I mean, incontinent, and yet here he is with this lifetime appointment and unwillingness to step down because his perspective was just so important, he felt.
And we're still here.
Exactly.
Yeah.
Exactly. I mean, you know.
One of the other concepts, some of the Republican candidates want to give Congress the right to overturn a Supreme Court decision with a 2/3 vote, which is a bit shy of a 3/4 state legislative amendment to the Constitution, number one. And number two, I don't know why anyone would want to turn over the ultimate constitutionality of something that Congress has a vested interest in seeing upheld, and that we have less than 15% of approval rating for. I don't think that's a good idea.
Well, I think you and I both have dealt with legislators. You and I have both evaluated their understanding of the Constitution, which is the ultimate law they're supposed to be enforcing. And I have found many of them to be wanting in that area of even understanding what it is that is the underlying support of the entire legal system that they're supposed to be working under.
It's worse than a lack of understanding. There are a number of congressmen who are unashamed to say they don't care what the Constitution says. That's where we are today.
Right, and that if they're going to get reelected, they have to vote a certain way to please an audience.
And that, unfortunately, or fortunately, however you look at it, is our fault. I mean, the people need to get educated again, as Jefferson said. This is most important, that a free people stay educated about our freedoms and our Constitution, because if we desire someone to be elected over and above their own limitations of the Constitution, we are in serious trouble.
You know, we talk about the rule of law. I mean, that term is thrown, I mean, you see it in movies, television, you know, I mean, a lot of people, it's on the tip of their tongue. But when you ask them, well, what does that mean? You know, what's the rule of law? Well, they don't understand that that's versus the rule of man. In other words, Saddam Hussein was the rule of man. I mean, whatever he said goes. It didn't matter how weird it was. If you weren't, you know, if you weren't crawling, if you weren't kissing, if you weren't doing whatever it is that that was the law, and if you don't, then he gets to make all the rules about you, as opposed to the rule of law in which some body of people came together and said, here are the rules, and everybody has to live by these rules.
And they can only be changed in certain ways, and ultimately in our nation, the rule of law is the Constitution and its interpretation, and in effect, the limitations on the various branches of government that have to be honored.
Right. which brings me to an area that you didn't want to talk about.
No, I can.
But I do, and that's executive orders.
Sure.
It's very strange. I mean, in the Constitution, the president is given the responsibility to see to it that the laws are properly executed. And that from this has been extrapolated this concept of executive orders, which is actually legislative fiat by the executive branch, in which the president originally, when this all started, was George Washington was telling his department heads, here's what I want you to do. You guys who work for me, this is how I want you to behave. But over the years, coming to FDR's decree that I need to round up all these Japanese out there on the West Coast and put them in internment camps. Truman's order to integrate the military. Eisenhower's order to integrate schools. I mean, some of them are seen as, yeah, well, this is a good thing, but do we want to come into a position where one guy, it's always been guys, makes this kind of a legislative decision? Again, it seems pretty despotic to me.
The framers were very, very concerned that our three branches of government might become blurred, and that if their separate power was not honored, freedom would be lost, anarchy would prevail. We have come to a point in this nation where things have either become so complicated or power has been usurped, exceeded, to the point where, in particular this president, it just seems like every time Congress doesn't want to go along with him on something, he suggests that an executive order will take care of it for him. And that is a dangerous proposition.
It's not just this president.
I mean, has others as well, but I've never seen it this bad.
You've got, well, the examples that I have named. I mean, you know, George Bush and Bill Clinton had a series of, a long series of executive orders.
Unfortunately, Lee, some of that is the fault of Congress. I know that some congressional acts ultimately give the president authority to tweak it here or there. And that's how all this got started, in my estimation, and it has just gotten out of control. Out of control. And we need to get back to the separation of powers, which the framers were ingenious with this program, to keep these different powers, legislative, judicial, and executive branches, separate, or if one gained too much power, really all would be lost. We're very close to that.
Well, you need sensical kind of people to take the nonsense and straighten it out and bring us back into a balance. And boy, at this stage, it just seems to me that there are people who, like you said, there are people that know that they're doing what is against the Constitution, but they don't care. They want what they want.
Well, unfortunately, you mentioned being reelected. 30 years ago in Edwardsville, I talked to an alderman in advance of a vote on an ordinance I thought to be unconstitutional. Out in the hallway, he agreed that it was unconstitutional, but he said he was going to vote for it because he wanted to get reelected. And so, I don't know. It's a problem.
You wrote a book. Let's go on.
I did.
We talked about that a little while ago. Let's get to the book.
Well, it'll be out in 3-4 weeks.
We got about 5 minutes left.
Okay. The name of it is "It's Okay to Say God." Eventually, a few weeks here from now, it'll be out in hardback and e-books and on Amazon and all those sites. But I became frustrated in the last several years as I teaching these Constitution Clubs of one particular area, and that is the religion clauses of the First Amendment, freedom of religion, and the prohibition of establishment of religion. Our populace knows very, very little about the truth of the interpretations of these clauses. I think they believe the Supreme Court is out to do in Christianity. That is such a false conclusion. And on the flip side of that, there's a lot of rumor going around that, as Lenin said, eventually would become the truth. And I'm trying to dispel that. with this book, and I address
the gist of it is.
Well, the gist of it is, on the one hand, when people like Sean Hannity, I remember after the president was inaugurated, he played some clips of kids chanting to the president. And Sean said, isn't it a shame that we allow that in our public schools, but we can't say God in our public schools? And that's false. That's false. Now, which came first, the chicken or the egg? I mean, once in a while you hear of some teacher being disciplined for maybe referring to the Creator in the Declaration of Independence, or even God at all. And I don't know what started first, but that's just not supported by the Supreme Court of the United States. Something like that.
But it seems to be in some places by various school boards.
Well, it
again,
does seem,
people who are elected and don't care what the rules are.
But how did that start? When if Sean, I love you, but I mean, when a guy like Sean Hannity says we can't say God in public school anymore, an awful lot of people will take that as truth, and it's false. It is false. Mm-hmm. That's one side of the coin. The other side of the coin is conservatives bemoan, for example, a government-sponsored and drafted 20-second prayer that cannot be said in public schools. But the case law, the dicta in the cases is to the effect that you can pray all day at school if you wish, on your own or in groups or around the flag before the school starts. Any number of ways you can profess your faith in this free society. It's a 20-second, government-sponsored, government-drafted prayer. Now, I always ask my club members, would you suggest that anyone in Congress could draft a prayer to be said by your children every day in school? And of course, they rail against that. Mm-hmm. In my book, I have a fictional family that moves from Lubbock, Texas to Berkeley, California. And the daughter goes to school one day and comes home and says, Mom, we said a prayer today in school. She investigated that, and it was the prayer of Scientology. So what I'm suggesting to you, and look, my book works. If you plug in different faiths, different denominations, the answer is always the same. Mm-hmm. If you rely on government to do your praying, you may find your kids saying a prayer of a denomination or a faith or religion you aren't particularly happy with. Mm-hmm. And we better watch that. My point is that case was very well decided, appropriately decided, for very good reasons, and Christians need to take care of prayer in their own families, in their own churches, and even out in public, but not get intermeddle with the government. It's dangerous.
It's very dangerous, and well, you're going to come back at some point in the not too distant future. We're going to pick this up, unfortunately.
I'd love to.
There's a guy over there that's telling me that our time is just about up. Your book is going to be coming out, I guess, the first in 2012, somewhere around there?
I think it'll be out before the year's over.
Okay.
Yeah.
Well, thank you very much for being with us today. And to my audience, I've been speaking with Tad Armstrong, an Edwardsville, Illinois attorney, head of the ELL Constitution Clubs. All of you, we'll see you next week. Thank you.